emergency to order at 8:33. Thank you all for coming in this morning. First item on the agenda, or item number 2 actually, is roll call, please.
Chairman Colapetro.
Here.
Sam Vincent.
Here.
Bob Mills.
Here.
Henry Bird.
Here.
Bob Thinis.
Excused.
Rex Sims.
Here.
Fred Forbes.
Here.
Okay, item 3 is review of the analysis by Special Counsel Beverly Grady on the Bonita Springs Shelter Operation Use Permit and Social Services Zoning Ordinance with final input prior to scheduling for public hearing. So,
Yes, good morning. Just to give a introduction, I used the name Beverly Grady, but I could have put Rutzel and Andrus. So today we do have Bob Pritt. He's board certified in city, county, local government. I can go through his credentials. You've met him before, I believe, or most of you have. And Bob will be assisting instead of Beverly today.
I was going to say, he doesn't look like Beverly.
No, and I think Beverly's grateful for that. So, you also have a memorandum, and I want to point out the memorandum addresses the analysis primarily for the operational. It does say that it has the zoning. There are some duplications and redundancies, but we'll probably get some additional information on that, or we may be going forward. At this point, Bob, do you plan to do it as a we didn't even talk ahead of time on this, as a presentation as to your findings? You reviewed both ordinances.
Yes, I'll be glad to go through this. Again, primarily, my assignment was to review the proposed operational ordinance. We did have discussion concerning the zoning ordinance. Again, my name is Robert Pritt. I'm with the law firm of Rutzel and Andrus. Beverly would like to be here, but she came down ill with the flu yesterday, so she just cannot make it. And so I'm here to try to make the presentation on her behalf. I think you're going to have a PowerPoint today also on the zoning ordinance, are you not, from the staff?
Yes.
Yeah. So if it's okay, I'll hold off on that and try to get through this 28-page tome that I blame the city for, because 18 pages were the city's work, I guess. And but what I try to do is make comments. If I can get into that, the operational ordinance. Start out by trying to make a fairly brief analysis of things that you probably know as an LPA, but I don't know that everybody in the audience or in the city would necessarily know or understand that. And that was a brief analysis as to basic law concerning drafting of ordinances, adopting ordinances, and those types of things. Again, most of you know, I'm sure you've been told by your city attorney that all ordinances, all regulations, state, federal, any type of regulation of the government in the United States has to follow a certain number of legal criteria that are set forth and interpreted from the U.S. Constitution, or in Florida, the state constitution. And so with that background, we did give a little page or two on the background of those requirements. And those requirements are things like under what we call the substantive due process requirement of the 14th Amendment and of the Florida Constitution. Every regulation must show that there's a rational relationship between a legitimate government interest and the ordinance itself. In other words, what's the problem and what is the solution, in layman's terms. And if the problem, sometimes the problem is none of the local government's business. Maybe it's the federal government's business. For example, if you were trying to locally to enter into a treaty with France, you don't have the authority to do that. And they're just a laundry list, immigration laws and things like that. It's just a laundry list of things you can't get into because you are preempted from doing so by either the Florida Constitution or the Florida statutes or the U.S. Constitution or federal statutes. So that's one thing. Rational relationship between a legitimate government interest. In other words, is this any of your business? And then secondly, It has to be consistent with individual liberties, which is another way of saying, is it consistent with federal or state constitutional requirements? First Amendment, Second Amendment, you can just go on through any of the amendments. A big deal right now today is Second Amendments with handguns, things like that. And that issue on a national level is coming right in front of us. Well, it's the same thing with regard to local ordinances. Obviously, this is not a handgun ordinance, but it's typical of the same analysis. Is anything that you're saying in your ordinance inconsistent with the federal, state law, or constitutions, or with individual liberties? And relevant to that, this particular ordinance may infringe upon or may in some way deal with certain things like right to travel, right to what they call freedom of movement, the right of people to be able to beg for alms, panhandling we call it, all those kinds of things. And each and every one of these issues has a very long a long line of cases that obviously we don't have time to get into. But is panhandling illegal? No. Is aggressive panhandling illegal? Well, maybe. And then off you go on to that analysis. So what I did and what we did is we looked at the ordinance as drafted, the draft that we had, and the city attorney asked that we look at it primarily with a view as to whether or not it is valid, what we call on its face, what we call facial validity. Is it valid on its face as opposed to validity in its operation? And as I say in the memo here, it's validity on its face. You don't see that as often, but that's what you should be concerned with right now. Validity on its face. Do the four corners of this document that you're presenting on the face of the document itself, the words in the document itself, do they indicate that there is or may be a violation of federal, state law, constitutions, et cetera? And that's what you want to avoid at the time that you are recommending a presentation to council of an ordinance. A lot of ordinances are perfectly valid on their face, but in their operation, they are invalid. And that's the second tier. We always want to kind of look to that possibility. For example, if you have an ordinance that's, let's say it's just a perfectly legal ordinance, there's no problem, but in fact what the police or the sheriff are doing are going in and, let's say homeless, they're going in and they're rousting them, taking them away from where they are in encampment. They're conducting searches without having appropriate warrants, which is a violation of the Fourth Amendment of the U.S. Constitution, or without having cause for that search. If that is actually happening, then that would be a violation of the Constitution in its operation, but not on its face. So the idea is not to stumble up front and put things into the words of the ordinance that can be challenged on their face. Believe me, there are a lot of advocacy organizations that are watching and would be watching and would be very happy to challenge the city on its face. So with that background, we did the analysis and did a recommendation, we put in recommendations as to what you might do in order to avoid the various problems that have been identified. And I'll try to run through that as quickly as possible. And I think your numbering is probably the same as mine. Going to the ordinance itself, I think it's on page 6 of 28. We made some recommendations concerning the title, but the title's done last usually. Usually you do the words of the ordinance, and then the city attorney puts in the title to reflect the ordinance. The only comment I had on that, do y'all see that, where I put down, we put down comment, and the ordinance doesn't mention the word shelter, or homeless rather, it just mentions shelter, and so there could be a question, is this, what does this apply to? Other types of shelters, picnic shelter, and you go to the whereas clauses and it becomes obvious that it is for homeless shelters, so that ought to be put in the title. But that's, again, that's something that I'm confident gets done and will be done once you figure out what the words of the ordinance will say. We made similar comments on the whereas clauses, but the one substantive comment on the whereas clauses, by the way, those are good. Whereas clauses, we city attorneys put those in all the time, and we usually put them in to give some evidence to a court that might be reviewing this as to what the city council had in mind when they were doing this ordinance. But one of the things that was a little bit troubling is on all the whereas clauses, there are recitations as to how this is an extraordinary burden, which I think we need to watch out for because it's just part of doing business as a city as opposed to an extraordinary burden. I would rather see something like a significant financial burden, things like that. And also, we recommend a whereas clause that says at least something about the rights of the homeless. Again, we're talking about the four corners of the document, and a reviewing court would look at the whereas clauses and say, well, where's the thing about a recognition that homeless persons have some kind of rights? It'd be very easy to put in there, and that would make it a little more balanced. And then getting into the effectuating sections, again, there's no mention of homeless, and then getting into the findings and purposes, I'm on page 8. If I'm going too slow, tell me to speed up. If I'm going too fast, tell me to slow down. The comment on page 8 is the first paragraph. I already said extraordinary additional burdens can be interpreted as a special bother language and that can be used to challenge the ordinance. Again, we don't want to have a challenge just by accident. We don't want to have an accidental language in there that could open us up to a challenge on where it looks like we're talking about additional burdens. And more importantly, there is a reference to residents, and we'll see that again later on. But essentially, there's a proposed 6-month residence requirement for admittance to a shelter under Section 4. And as I say here under B, homeless persons are by definition somewhat transient, and it is assumed they would also have a need to be sheltered. A homeless shelter that meets only part of the identified need may be insufficient, and an ordinance that purports only to meet the need of residents for at least 6 months may be under-inclusive and subject to challenge. Again, in one of the requirements is for any ordinance is that it can't be vague, it can't be arbitrary, capricious. Over-inclusiveness, under-inclusiveness are aspects of that. So you want to make sure that you're really addressing what it is that you say you're addressing. If this is a homeless shelter, but it's only for residents, somebody that can prove residency in the city for 6 months, then that is pretty inconsistent with what the actual homeless population might be. And we'll go back to that when we get to the other section. On page 9, Section 4, application, a person who wishes to establish and operate a homeless shelter shall file an application for a shelter operational permit. And that's a good idea. That's what this is all about. The permit will show compliance with the following requirements contained within this section. Then there's a pretty large section that talks about all the things that must be met. One of them is an identification check. The courts are not very keen on having people having to have identification, carry identification in the United States and in Florida. Now, you may have to have some type of identification for certain benefits, Social Security benefits, to prove veterans benefits and things like that. But just to have them and have to carry a piece of paper in a pocket somewhere. The courts have been, including the U.S. Supreme Court, have been pretty tough on cities and states that require people to carry identification. There has to be reason for that. And I think that this is a pretty easy fix, and that would simply say, or another form of identification, rather than a form of identification that's required by the State of Florida Division of Motor Vehicles, because the homeless don't drive generally. Just have a clause there that says, or provide identity and other information sufficient for the shelter to determine whether the person should be granted admission to the shelter and qualify for assistance. That's a simple little fix that can keep you out of trouble on a facial invalidity challenge. And then it says 2 proofs of residential address in the city of Bonita Springs for a minimum of 6 months. That, again, that can be problematic. When I came to Florida, I moved to Sanibel, and the day I moved there, I was a resident of the state of Florida and in the city of Sanibel. Period, end of story. So a homeless person, the Supreme Court of the United States requires only 2 things for residency for purposes of domicile, and that is, 1, a residence. Well, we could argue whether or not living on somebody's property constitutes a residence, but that's where they are eating, sleeping, et cetera. And 2, an intent that be your residence. That's the only 2 things that are required. Everything else, including voting and where you get your driver's license, all that, and what you say about homestead, all of that is evidence of that intent as opposed to being intent itself. So to require somebody to be proofs of residential address in the city of Bonita Springs for a minimum of 6 months, my guess is that most homeless don't even know what the residential address would be of the place that they're living, and for obvious reasons. So we would recommend that be not part of the process. And I know that that's a big political problem, but I'm not here to talk about the political aspects of it. I'm here to talk about the legal aspects of it.
Let me ask you a question.
Sure.
Do you think that a lesser period would be something more, if it's a shorter period, would it be more entertainable? Because there is some case law out there that do have residency requirements that have been upheld in other jurisdictions. City of Elgin is one of those.
Yeah, we had discussed that. I don't think it's going to make too much difference. And I think you're going to be open to challenge regardless because, and I understand the City of Elgin case, but I think that can be problematic. Want to leave it in and find out? One of the problems is it's very expensive to litigate a federal court case, any court case, but especially a federal court case. And if the other side, the plaintiff, in any case, I'm not talking about the homeless case, but any case, is able to convince a judge that there is a violation of their civil rights, then they get their attorney's fees. And there are attorneys out there that will take those kinds of cases if they think it's a good enough case, and then so even if you paid $1 in damages or even $0 in damages but had to change the ordinance, they still get their attorney's fees, usually at least $250,000 in cases like this. You're talking hundreds of thousands of dollars in federal cases. So it's a consideration. If you want to chance it based upon Elgin, that's 6 months is no worse than not much worse than 3 months or 2 months. It's more a matter of, in my opinion, more a matter of quantity rather than, or of quantitatively, that is, either you should do it or not do it, as opposed to how long the residency period is. It's not like they're running for office, but,
Those are discouraging. We've lost those in court and had to pay attorney fees. Fortunately, state
Well,
government. We lost
You
that.
lost that one?
Yeah, I
Oh.
lost that one.
well, that was 2 years, wasn't it?
It was
More
a-
than 2 years.
Was it 2 years?
Yeah.
Yeah.
Yeah. I won one many years ago in federal court on a 1 year. Okay, so the other one is advising shelter resident of the rights and responsibilities. And D, all applicants will be screened at intake to ensure they're not under the influence of drugs or alcohol, and so on. That's okay. I suppose in operation, I don't know if that works. A lot of the homeless are brought in the middle of the night, often on a cold night, and whether or not there's time to do that type of intake at 2 o'clock in the morning is another issue. And one of the things it can't be is it can't be unreasonable, arbitrary, capricious, or unreasonable. And if nothing else, somebody could challenge that as being unreasonable. It just doesn't work. Drug testing is probably okay. But anyhow, my comment there was simply, with half the homeless in some shelters being addicted to drugs or alcohol, this may lose its usefulness by being overbroad. And there's a citation, I believe that footnote 20, there was a recent article in the newspaper by St. Matthew's House, and they indicated about half of them have, half the homeless have addictions to drugs or alcohol. Obviously, that means the other half don't, but it is a consideration. And then the conviction of crimes, I think there's a pretty easy fix for that. It doesn't say anything about a case that's pending or a case that's where somebody has had his or her civil rights restored. And I think that's a fairly easy fix for that. And there is case law that says that clearly you can have rules that do not allow sex offenders, registered sex offenders in these homeless shelters. So I think that's just a drafting fix. What the recommendation is to consider requiring the shelter to provide a plan as to how to deal with these classifications rather than an outright ban. One of the things I say in the paper, one of the things we learned actually from the eminent domain cases in the U.S. Supreme Court is local governments should never say never. You always have some type, if you can, have some type of an out where it's just not, it's not absolutely, this is an absolute ban, and no matter what, nothing else can ever be, no circumstance can ever change that. So quite often we will instead have some type of an escape clause where somebody is not automatically thrown out or the shelter closed down without there being, just because somebody had to do something under the circumstances that was necessary to do. Another thing was a recommendation, so consider requiring shelter to provide a plan as to how to deal with these classifications rather than an outright ban, and there may be shelters that can handle other classifications. We're talking about a homeless shelter, but as I've kind of learned in going through all of this, there are homeless shelters and there are more homeless shelters, and it's a bit more of a process than just I think what this proposed ordinance is dealing with, and that is it's really requiring there to be what I would call a really fancy homeless shelter, and it does not, in my opinion, deal with the situation where the police just have to find a place for somebody who's not doing anything wrong, but they're cold and they need shelter, and I don't think this covers that. The main recommendation that we have on that is that you might want to first identify the need. What is the need in the community? And that's hard to do with homeless, but it can be done, at least estimated need. That's the level of need, how many people might be homeless, what the rationales are, and things like that. And then try to address the need. And I don't know what level the city has gone to try to address that need. But it may be that you don't need that much, let's say 50-50 is alcohol and drugs. Well, maybe that's a different type of homeless shelter, a different type of shelter that is needed than the temporarily homeless type of shelter. But again, you might want to start off by looking at the need and then crafting the ordinance to address the need that has been identified. And that also helps you with your legislative history to show the rational relationship between the problem and the solution that's been proposed. And then some other things on the bottom of page 11, discharge, leaving the shelter residency. There's some probably very good, is good language in here concerning not wanting somebody to be discharged in the middle of the night, which makes sense. Again, we're recommending an out clause there because you can't keep somebody against their will if they haven't done anything wrong or they're not subject to being Baker Acted or Marchman Acted. We learned that in Naples the hard way under the Marchman Act and wound up in federal court. And the Marchman Act is in Florida. The Baker Act is somebody who is a mental illness type of, where somebody is sent to a David Lawrence Center or whatever it may be for a mental illness problem. And the Marchman Act has to do with someone who is deemed to be a danger to himself or herself or others. And it could be somebody has drunk too much and they're drunk and in the streets or next to the streets and so on. Quite often they're taken to a hospital or to a treatment center and they're kept, but they may or may not be, they can only be kept for a short period of time until they're no longer a danger to themselves and others. And sometimes we have problems with hospitals saying, okay, you're out of here at 3 o'clock in the morning. Now they're back on the streets. So those are Marchman Act, what we call Marchman Act in Florida. Well, there are some rules on that. They can't just do those things without a hearing or a good reason not to have a hearing. And actually what somebody, what the claims are is that if they've been arrested and sent down to jail because there's no other place to put them, then that's false imprisonment. And that violates the constitutions. So with homelessness itself not being a crime, it becomes a problem as to how to handle that. I presume you've talked to the Sheriff's Department or will talk to the Sheriff's Department. I'm sure that they have some tremendous input into what should be done. There's also a provision in here that that the person is supposed to, the shelter is going to be required to get a zip code for where the person's going if they're being discharged. I don't know if the homeless person knows a zip code. If I were the homeless person, I'd make up a zip code, and then the shelter lets them go. But the police, you've heard the old story or the old term, putting a tail on somebody. Let's watch out for them after they get out. Well, if they haven't done anything illegal, then you can't. Even the police can't put a tail on them, and they won't. So that won't work with the current language. Again, I think it's a fairly easy. There's a fairly easy way to draft something. They can ask, but to tell them that they, in the ordinance, that they're required to do that is probably going to be not be upheld, in my opinion. So there's a recommendation there as to how to do that. And then the independent living plan on 13, and thereafter. I think mostly it's okay. There are a couple of things in the comment, and I'm on page, bottom of page 13. The comment there is that, as to A and B, there may be, a lot of these requirements are good for shelters that are going to really be providing a lot of services, but again, what about the shelters where you just need to have a place to get somebody for a night or two or a week or something like that? The question is whether or not, again, that's kind of a never say never type of argument. So, is that an unreasonable burden? And is it going to solve your problem? So you might want to consider making that, making provisions for shelters that provide, or for the shelter to be able to provide for the basic and emergency types of needs without having a lot of the other baggage that goes along with that. And that, for example, medication, having somebody, a social services person there, having a nurse there, that's probably a good idea, but I'm not sure that all shelters actually do that or can afford to do that. And again, a way to get, not to get around that, but a way to deal with that is to make a lot of these requirements, independent living plans and these requirements, make these things that shall be submitted. Submit your plan, and we will review your plan for what it is you're trying to do, and it may be approved even though it's not a, quote, fancy homeless shelter. If it meets, generally meets our ordinance, then it can still be approved without the city telling them what all has to be in the plan. One size does not fit all. Going down to, and again, this goes to minimum staffing, so 2 paid staff employees and so on. Maybe that's probably a good idea. There are some references also to state law, keeping of medications, et cetera. Question is, do you want to get into making local requirements, those things that are already required under state law? If somebody is dispensing meds, then there is state law that covers that. I'm not saying don't do it, but I'm just saying, do you really need to be saying, well, you can't do this because state law says you can't do this, or you must do this? I'm kind of a minimalist in my writing, and I try to be anyhow, and that is, if something's covered by state law and it must be done in a certain way by state or federal law, then I generally don't feel a need to reiterate state or federal law because you invariably miss some state or federal law.
Bob, I want to ask you a question on this because this was a particular concern of residents.
What page?
On the point you're going on page 13 is to the administration of medicine. I had it originally, people wanting it where it was only to be administered by a registered nurse. So somebody who's an LPN, somebody who is a doctor would not be permitted to do it. It would only be, as a compromise, I put in someone authorized to do so according to Florida statutes.
Yeah.
The concern is that with self-medication, the concern is somebody not there responsible and sharing of no different than a high school,
Right.
sharing of medication situations that could occur in the shelter.
Well, yeah, I think that's a good idea. But to try to say that, I think there was reporting to the city of the requirement of what medications were being, where they're being provided, et cetera. State law applies that. So what I would recommend is just a reference to state law without trying to get into what the state law standards are, because as you know, state law standards could go on for hundreds of pages on things like, and federal law. We haven't talked about federal law. So that was my only comment on that. On page 17, there is there's a prohibition against housing first or rapid rehousing shelters being prohibited. And My comment was, why would the city prohibit this? This seems counter to the purpose of having homeless shelters. Now, that's all I said about that. That's all we said on that issue, but it almost looks like, well, we really don't want homeless shelters, period. I mean, that's almost code for, well, we don't want it. And the whole idea of having some type of service for homeless people is to make them not be homeless anymore. You have a 6-month residency requirement. They have to tell you what their address is, all these types of things. And then there's a prohibition against rapid rehousing shelters, moving the homeless from the streets or the homeless shelter into their own apartments. So that's an issue I think that you have to deal with, but it just seems counter to what the whole idea of having a homeless shelter would be. On the management and security plan, again, that's a good idea. Most of it's just fine. Most of the comments were that it's okay. The question is and I'm on page, just at the bottom of page 18. The second sentence is okay, although having them report annually might be more realistic. How often somebody has to report, if you're having unreasonable reporting requirements, or you're having reporting requirements that are monthly, quarterly, all of that type of thing. Two things happen. One, it's a burden on them. Two, and it's a burden on the staff. And, well, I guess three things happen, is eventually everybody gets the reports and they throw them in the file, and nobody pays much attention until all heck breaks loose, and then everybody starts pointing fingers at each other. So, again, it's driving up the cost of the shelter and also the cost of government, and that's it's just something you might want to consider about. On the next page, Roman numeral small 6, VI, facilities shall provide adequate indoor waiting areas and restrooms for visitors and intake of potential shelter residents, and it said citizen input, no visitors. No offense, but part of the idea, if somebody is in a shelter, a hospital, a nursing home, anything like that, probably the most important thing would be to be able, at least, to have visitors, it would seem, and help them. You can't assume that all visitors are going to be bad visitors. Family, friends, ministers, hey, maybe attorneys, whatever. I'd keep the attorneys out myself. But no, I don't think you can get away with saying that somebody could have no visitors unless it's under a detox program, et cetera. So that probably needs to be either kept the way it is, or certainly not a no visitor policy. And there's a little comment on panhandling later on, and that is under the site management plan. I'm on page 19 of the site management plan. Employees or volunteers of the facility shall cooperate and work with the city to stop all littering, panhandling, and loitering within a 250-foot radius from the premises. For purposes of this section, distances measured from the facility's property line. Citizen input is 3 miles. The comment there is a facility cannot be held responsible for off-site activities of persons not within their control. This does not purport to be limited to residents of the facility. A shelter has no legal authority to stop such activities. Panhandling and loitering are not necessarily a code or law violation, as I said earlier. They have their own elements, aggressive panhandling, that are or can be in ordinances that apply to all, not just a homeless shelter. The whole nature of an ordinance is that it applies to the public in general, and not just to one or another organization or person. So that's one that really is open to challenge. There might be a plan. It might be that they provide a plan, and I think that's what the whole idea is, a plan to help address issues like that, but to make them responsible, to go out down the street 3 miles or whatever it might be to stop panhandling. They don't have the authority to do that.
And I just want to point out to you, and I sent a memo, I think last month, there was a case that came out in Sarasota regarding panhandling, where they had cited it under definition, but they didn't actually have a prohibition. I went into our ordinances along with the county ordinances. We don't have anything on panhandling. So currently, if people wish to panhandle in Lee County, there's no prohibition against it. There is if there's maybe some aggressive behavior that can be cited under something differently. I don't think that we're going to get a lot of buskers as a result, but just make you aware of that. You can't make a crime if you don't define what that crime is, if people don't know what it is.
That's correct. And I think I indicated we can concur with your input on that. Same thing with the type D buffers. We concur that usually goes into the land development code. And bicycle parking, I guess you're okay, but be careful about if you're not requiring that for anybody else, is it something that you should require here? Do you require that for City Hall? I don't know.
Be nice.
I don't know. But just be careful about whether or not again, we just don't want you to step into what we call a trap for the unwary, saying we're going to have all these rules, but it's only going to apply to them, and it's not going to apply to us or anybody else. And the question is, why? Well, because I said so. Oh, that means it's arbitrary. And you lose the case, and you have to change it, and you have to pay money for challenges. And a couple of other things, a couple places I talk about things that are covered elsewhere, and it's called in the law sometimes surplusage or redundancy, and we've outlined some of those. The shelter being built to Category 4 standards, that might be an issue for you all to talk about in the context of what your shelters are, other shelters are. I don't know what the city's policy is. I know what the policies are in other cities in the county to some extent, but generally speaking, if you're going to make somebody build their building to Category 4 standards or to Hurricane Force standards, generally the government's going to help pay for the difference between what your code says it has to be and what you are saying it has to be for an emergency shelter. Lee County did, I don't know what their policy is now, but they were actually encouraging that throughout the county, and they had new churches that were being built, new assembly halls that were being built, and they required being built to the standards, but you also entered into a 10-year agreement, and they came up with money. So you might have to be prepared to come up with money. And then if you only require that of a homeless shelter and you don't require it of other similar buildings, then you're back to the arbitrariness and capriciousness issue. Floor plan, just a little comment on floor.
Excuse me. Can we go back up to where it says that, I think it's under 10?
I'm sorry, what page you on?
We're on the same page.
Okay.
Just go up 2 paragraphs. Where the facility shall implement other conditions as determined by Community Development Director in the comment.
Oh, yes, I'm sorry I didn't mention that, yes.
Is the comment that should be eliminated completely?
Yeah, kind of. I'll tell you why. There's a case called Loudermill versus Board of Education of Cleveland in which the Supreme Court said you cannot have, and do I have the right case?
It's an administrative law case
Yeah.
as far as if you have too much overstatement to, oh, this is great. I feel like I'm in law school again. if you can't, you have to give very defined rules to administrators, because otherwise it's an unlawful delegation of powers.
Yeah, it wasn't the Laudermill case. There's another Supreme Court case, the name of which escapes me for a moment.
It's not Manel. You're not
No,
trying.
no, in which the Supreme Court, it was a Newsrack case, the Supreme Court said that that a local government, or any government, cannot delegate, the city council cannot delegate to the staff the power that the city council has to make what amount to amendments to the ordinance itself. It's called an unlawful delegation. If you delegate something to the staff, you have to put in standards for the staff to follow. So a standardless delegation to the staff or an unlawful delegation to the staff would not be allowed, and that itself could be easily challenged. And it's kind of like shooting fish in the barrel on these things. It's pretty easy to tell whether or not it's a delegation.
Right.
The other problem you have is if you give too much power to the staff, then it is, because they're administrative, this is all part of separation of powers. If you give too much authority to the staff, then that can be deemed to be a self-amending ordinance, that takes away the power of the people to come in. Whenever an ordinance is adopted, you have hearings like this one. City council has hearings. And if the staff just is allowed without any standards to make the determinations and to do what is the council's function, then that beats the public out of having meaningful input. It avoids the requirement that we have in Florida of having hearings and things like that. So there are limitations on that, and I know that you've dealt with that in
Right.
other
But let me
concepts.
go on the other side of that issue, and generally, when there is a challenge, it's based on a particular condition that staff has implemented. So it's an as-applied challenge as opposed to a per se challenge, which generally means you don't end up losing the ordinance, you may end up losing the case. You still have attorney fees, you still have other damages, but it might apply to one application, it would not apply over the board to everyone. It's still a very difficult situation. If staff creates a condition, and it's an unlawful delegation, there's still some problems. There's also problems internal to government, because are they then exceeding the scope of their duties? Because then they could be subject to personal challenges against them, that they've exceeded their authority. And then that runs into a legal quagmire as to who defends them, because there's actually, at that point, the city might not be agreeing with staff. The city might be in the situation of, the city legal and council may be saying, staff, you have to have your own representation because council did not agree with what you did. So putting that person then into a 1983 situation, or putting the city in one, and a lot of that also deals then the city getting into trouble because of training. Does that all make sense to you?
Well, I guess no, it doesn't, but my question now would be, does that need to stand or need to be rewritten?
That needs to be rewritten.
Okay.
I think we both agree on that. By the way, it was the Plain Dealer case I was thinking of, Cleveland Plain Dealer
Okay, so you're
case.
still in Ohio.
One of the
Well, that-
conditions we had in here was the meeting, the public relations meetings that were had, and obviously, over time, conditions would come up that need to be changed, and those could be recommended originated in these neighborhood meetings. And so I look at it and say, it talks about neighborhood groups. I'm assuming that they're going to offer suggestions. But then my question comes up, then, if there is a suggestion made, how is that implemented?
And that's a good point, because generally with ordinances, the citizens, the LPA, city council, staff, all of us, none of us know exactly what may be happening in the future. I mean, none of us I presume none of us have that capability. And with that being said, we would amend the ordinance for things that, as it occurs, as long as it's legal to amend the ordinance, as time goes by. So if we discovered that some things occur, if a shelter is located in the city, and if certain things occur, we can then have certainly an operational, because it's regulatory behavior, it's not a land use, so there's not a non-conforming issue. We can regulate to allow that conduct, to be corrected, or that behavior. Or we could relax the ordinance if some things that we thought were things that were a concern turned out not to be a concern in the future.
No, I don't exactly follow. Any change in the operational contract that we're writing here, you're saying then would have to go back and go through the whole full-blown city council procedure rather than having, let's say, simple or minor changes made by the community development director.
As far as any condition, you're talking about as in the permit themselves, the operating permit, or are
Well,
you talking about the ordinance?
It's specifically that's one of the questions I had in my mind about why we listed the community development director here as an ongoing monitor in this situation, because it appears to me that once they have their permit and they're in operation, he's kind of out of the picture.
I don't believe the ordinance is drafted that way. I saw the ordinance of no different than if somebody has hen laying permit, if somebody has any other type of permits. I mean, there is a department ultimately responsible, and if there
Yes,
needs to be a
but not-
revocation of a permit or.
This indicates to me that the community development director is in constant, help me, supervision or is constantly connected with the operation of this thing, which is a little bit different than other things that we do in the city.
Well, with all permits, I mean, it would be an oversight, but it does not mean a daily oversight. It would not, hopefully, it would be no different than the building director does inspections when somebody pulls a building permit. They do about, 5 inspections or 6 inspections?
But
I usually say, if I'm drafting an ordinance, I usually say the city manager, because that covers the community development director and every other employee of the city except the city attorney. Who'd I miss? I think, yeah, you have. And
Person, the neighborhood group would take their concerns, for example, because neighborhood groups are specifically mentioned here. So just using that as an example, a neighborhood group would take their concern instead of to the community development director, who in my mind is by this time out of the picture, would take it to the city manager, which would then be the procedure to go to city council.
Okay.
I see what you're saying, Rex, and one of the things I look at here is that we've run across this in all of our meetings, is that in consultation becomes problematic, particularly when you're talking about neighborhood groups, and it's relative to quiet, safety, and cleanliness. So you're getting biased opinions that have to be determined by, say, the development director, which is not very clear. And is that substantial? Will it stand? In other words, we get a biasness because we don't like the center, and so we get to play a role here in talking to the community developer director about what's going on there. So we apply a lot of pressure here to make things happen when, in fact, maybe the city council needs to be addressing this rather than the community developer director.
Then you take your people off the delegation issue.
Yeah, I guess my concern was less with who deals with this. That's kind of up to the city as to who deals with it on staff. I normally put down the city manager, and then somewhere in the code, anywhere, the definition of city manager, you may even have it in your code. The definition of city manager means the city manager of the city and any person to whom, any employee to whom he or she delegates such responsibility. That way, you keep yourself out of figuring out who's going to be running which department, handling that. So totally on a different plane, I think you're correct. I mean, I would identify the city manager. Now, maybe if you're saying it should come back to the city council periodically, I think that's a choice that you can make. What my concern is what this says, the facility shall implement other conditions as determined by the community development director in consultation with other city departments and neighborhood groups necessary to ensure that management and/or residents maintain the quiet, safety, and cleanliness of the premises and the vicinity. Now, that is clearly, in my opinion, delegating without any standards.
That's correct.
To the staff, whoever you want to call it, and to the, as determined by, in consultation with other city departments and neighborhood groups. Well, you got to be careful because you don't want to accidentally be deputizing neighborhood groups to act as city council members, with due respect to neighborhood groups, and they're very important, and their input is very important. They did not get elected to the city council or appointed to this board. So you need to, you don't give the staff the authority to get with neighborhood groups and to automatically put together other conditions. So it's the way it's worded, and I think you can probably draft around it and solve the problem by having, maybe an annual consultation meeting or something like that, whether it's with the city council or with the LPA or with staff.
Well, that was precisely.
I don't care legally. It's up to Audrey and all of you as to
That was
how you-
precisely my point,
Yeah.
is subrogating some responsibilities here to neighborhood groups, for example, and the community director to make a decision, when in fact, the council should be involved with that.
Well, as a matter of policy, I'm a little more in favor of the council doing its legislative duty and letting the staff do what the staff can do to implement the policy that has been dealt with by the LPA and eventually approved by the city council, rather than having everybody coming back to city council meetings all the time to try to change something. But if you want to have something in for a periodic review, that's probably not unreasonable unless a periodic review is every day or every month or
Right,
every quarter.
And I think a periodic review, it's kind of a reservation of rights to do so. It does not mean city council is going to do something. And generally, if people think sometimes an issue will come to city council, a lot of times they abate the issue or resolve the issues amicably internally instead of having it come to city council.
So we're
But
just,
we
Just as
specifically,
a reservation might be a better way to address it.
one of the things that alarms that goes up here when it mentions neighborhood groups, we specifically have written in here a good neighbor plan where they would have coordinated meetings with the neighborhood and so forth. So that indicates to me that we are asking for neighborhood group input. So if we're going to have neighborhood group input, it's got to be worth something or it's not worth doing.
Right.
So it's got to go someplace.
And we're not disagreeing with you on that. I think what we're saying is, with the input, the information we obtain through the neighborhood meetings, between the shelter.
Well, I don't want it to
between
go to the community development director because in my mind, that person is out of the picture by now. This is an ongoing operation, and it should go to somebody in the city.
staff. Okay.
If we're going to have somebody going to report to somebody, it has to be report to somebody that has some authority to deal with it.
Well, and under the charter, the city manager is responsible for getting things on the agenda. So the city manager or the city manager, as they determine who they think should be on it or be delegated with the ability, will be taking it to council, so that treat this, in other words, modify this section so that it reads as a periodic review, reservation of rights to add additional conditions as a consequence. And we might move this condition more into the neighborhood plan area, so that it falls within there, so that as a result of these neighborhood plan meetings between the shelter and the adjacent property owners, there may be things that come out of that meeting that call for modifications to that permit as decided by city council. Or alternatively, it's possible that the parties will work it out amicably and it never goes to city council, but it's a reservation of rights.
Well, I just would like to be comfortable in the fact that if we don't have that phrase in there about the neighborhood groups, because we've gotten some very valuable input from these folks who have done a lot of research on their own.
Absolutely.
So I just want to be sure that just because it doesn't specifically state that their input will still be, if we have to take that out, that's what I'm getting at, or can we leave it?
I was planning on leaving it. The question that the attorneys have is that it's not the input from people. The adjacent, you do want to know adjacent property owners because you do want compatibility. I mean, compatibility is a
Exactly.
very important thing to us. I mean, for LPA, for council, for everybody in the area. So, I mean, consultation is not an issue with the neighborhood groups. The question is, who can modify that permit to add additional conditions? And that's something where the elected body, as opposed to a delegation of powers, and that was his concern. The other concern is it should not be something that is, now they're upset about this, the upset du jour situation, so you're having it where it's more firmly into a periodic review process. It's possible that, because we do have other cures if they're in violation of the permit in the ordinance, so a periodic, we did not think about this, now we'll think about it as a result.
Well,
And it could work both ways, things that we are afraid of might not come to fruition either.
I think it's perfectly valid to do that. Recently, the last few days since the 1st of January, you notice on television, you get these notices about reporting to the FCC any problems you have. Well, that's because annually or periodically, they have to submit to the agency a report as to how they're doing and whether or not they're in violation of anything. Well, having that type of a periodic review, I think, is perfectly lawful. But my problem had to do with more with the law being changed by the community development director or in consultation with neighborhood groups. That's totally different. I think this can be rewritten in a way, one, to make sure that it is constitutional, and two, to ensure that neighborhood groups still have at least periodic, an opening for periodic comment. Obviously, you're going to hear from neighborhood groups if things aren't working out anyhow. I'll bet. But to have something put in there that mandates that, I would say probably every year, at least once a year as part of the annual reporting process, that might be a way of handling that problem. But that's a very perceptive observation on everybody's part.
Mr. Chairman, what I was going to do is wait till you got done and I had some questions and points, but since we've, opened the box of comments, going back to two areas, let's take one. It seems to me that it would be safe to assume that there's not going to be that many applications for permits for a homeless shelter coming into the city. Some manageable small amount. It would seem to me that since you're saying that no size fits all, and I can see that part of the review and the permitting process needs to be referred to spatial council, because you guys have got the expertise on a lot of this. I know this, you appear to know more about what we can do and what we can't do than our staff and us. So it seems to me we need
Your
some,
attorney knows
Yeah,
every.
a little
every
bit
bit
more
of-
offended, but that's,
no, I'm, no
she
offense.
knows-
No, Audrey is good, but I mean, you guys are focusing into.
She knows this area of the law.
Right.
Very, very well.
Right, but I still say, you're not gonna be dealing with tons of these. What is the harm in letting somebody else, another pair of eyes, look at?
Mr. Forbes,
Yes.
let me explain this to you.
Okay.
Under the way the city charter reads, as well as my contract and
Right.
everything else, I do hire outside
Okay.
counsel when I feel it's necessary.
Okay.
Generally, I had the issue yesterday on a employment issue.
Right.
So, but the attorney, if there's a need for legal counsel, and outside counsel, because I need additional expertise, and, I've hired Russell and Andrews, I've hired
Right.
other firms depending on the
Right,
situation.
okay,
I will do so.
Okay.
But allow that to continue to be my need to make that decision in consultation with my client, city council,
now the other question.
outside the
yeah.
scope of the LPA.
The other question I have is, and when I was looking at one of the latest rewrites, there was a talk about staffing, and I don't know whether the thing about having a, a registered or a licensed nurse and a licensed social worker on staff is going to survive. But if it does in some fashion, it seems to me that the latest version of this has got the staffing, that requirement upside down. What it said was they need to be there during the admitting hours. Now, if this place follows the traditional homeless shelters that we've all become familiar with, during the admitting hours, that's when the building is almost not occupied by the people that are staying there. So I think that somewhere that needs to be tweaked unless legal counsels say it can't be, to where maybe if you have an 8-hour day, maybe at least 6 to 5 hours, at least 4 hours, they have to be there when the residents are there, so that that if somebody, they can be observed by this social worker and things like that. Otherwise, we're going to have we call it the unlicensed people doing most of the observation in the evening.
Let me ask a question. Because again, this is no different than what a federal judge will be asking.
Yeah.
Why does a person have to be on the premises in the event of something? Why can't a person be on call and available? I mean, having a person on site, for example, saying, used to be, when I was growing up, there was a school nurse.
Right.
And then, economics with the school system.
Right.
It got shorter and shorter, then, it became just the school nurse, I think, for every 5 schools, unless you're a Title I school, because of the money and such. But not just the money. I mean, if there's not a need, if the nurse is not doing something, if the social worker is not actually needing to be doing social work, is that not now over-inclusive and thus over-breath, failing due process concerns?
No, I agree with you, Audrey. The only point I'm trying to make is if they're going to have in the ordinance a licensed nurse, a licensed social worker, it seems to me that it's not that illogical to say that they need to at least be there half the time when the building is full of people that the shelter's for. Otherwise, you really just make them on call and they don't get paid for a 40-hour work week. That's what I'm saying.
Well,
Now, maybe that's what legal counsel's saying we need to do.
I would probably need to check with my employment folks upstairs, but if you're going to require somebody to be at the facility at different hours, a shelter is going to need to have overlapping providers, because you're not, between vacations, sleeping, I mean, there are Fair Labor Standards Act
Yeah.
requirements that the shelter would have to comply with. You can't just have a person always on physical premises without paying them, so therefore, they will, I didn't realize we'd need Denise in the conversation. You would probably end up having some overbreath issues.
Mr. Chairman?
I think you have a very good point, and I think I won't speak for Audrey, but I think we both agree. Look to see what it is that they're going to be doing. If it is medication, dispensing of medication, state law covers that. You know, only certain people can dispense
Yeah.
medications. And as a matter of fact, there is currently a big fight going on between the nurse practitioner, as to whether or not a nurse practitioner, what the limitations are, a nurse practitioner prescribing medications, things like that. Those are things that are covered somewhere else, and all we need to do is determine what it is the shelter is going to be doing, which you find out in an application. What are you going to be doing? Is it just going to be to house somebody between midnight and 8 a.m. so that they don't freeze to death? Or are you going to be trying to do all these things that are mentioned in here? And a lot of those things are governed by federal or state law as to how that happens. And that's why I keep saying, don't have so many hard and fast rules as to what they must be doing in order to have a shelter. Have them submit the plan to you, whether it's in the context of a conditional use petition or under a permit under this ordinance, and let them tell you what they're going to be doing, and have them show you as to how that's going to be done in a lawful manner.
Bob, that brings an interesting question. If I were to make an application for a homeless shelter, how would I know what I need to include to meet the requirements that you're specifying here?
Well, there are groups that do this. The city had some experience with one of them, St. Matthew's House. They operate in Collier County and wanted to operate here at one point. They, like everything else, like a hospital or anything like that, they kind of know what it is they do, and they don't all do the same thing. And so when you get an application, you make them fill out the application and tell you what it is that they're going to be doing.
Well, I guess
And-
my
and then-
question, I didn't ask the right question.
Well, then it follows, what I was getting to, I think, it follows from that. Okay, we're going to do social work to try to get them back into, we're not just going to shelter them for the night. We're going to do social work to try to get them back into the community. Well, if that's the case, then you're going to have a licensed social worker. We're going to try to get them on a drug treatment program. Then you're going to have somebody who's certified in doing that. We're going to give out medications. You have to have a nurse, at least a nurse, that type of thing. So I'm not sure if that answers it. But they tell you what it is they want to do, and then you look to see whether or not their plan is a valid plan to accomplish that purpose. Now, did I answer it?
Well, let's go back. In the beginning, we had a definition of what we're dealing with here, and it was a homeless shelter, which is temporary housing. It does not require, or does not specify any rehabilitation or anything like that. It's strictly, this ordinance is to deal, the primary goal of it was to deal with a class, 4 homeless shelter, which is a temporary thing. So I'm saying if I were a client going to come in and make an application to do that, I would need to know what I'm going to be required to provide to do that. And so I think our ordinance needs to have some specific requirements as to the staffing requirements for me to meet this obligation with the city. If I was doing anything beyond that, it's really not covered in this ordinance per se.
And that's an interesting point. And I'll use the analogy of a restaurant. I mean, a restaurant needs to have a certain minimal staff, but if the city doesn't know how many people are, I mean, you wouldn't want the city to be creating an ordinance saying that when you have a restaurant, you must have at least 12 staff members there, when 2 could suffice or 3 could suffice. Likewise, you don't want to say that some number and then them needing more. I mean, they're going to need to be able to handle some of their own decisions. We need to probably make some ratio, and I think a population ratio as to what amount of occupancy could be permitted.
And, there's building code requirements as to square footage for any kind of occupancy. But other than that, I'm not sure, how invasive you want this ordinance.
Oh, I didn't mean to get us stuck in here, but we got another comment from Henry.
Yeah, I just have a suggestion here that maybe it would be better served if we let the attorney go through the entire document, because I'm getting lost because we're jumping back and forth into different sections. That's just a suggestion.
Fine, yeah, let's go ahead and continue.
Okay, we're fairly close to the end anyhow, my comments. I forgot what page we were on here.
We're on
20,
18 of yours. so.
Yeah.
Gee, I jumped to 22. I must have been fidgeting.
The
Hopefully.
adequate lighting, security.
Yeah, page, okay, page 18, let's just go and start at the top there. Shelter residents are not permitted to stay in a shelter for more than 30 consecutive days. And then it says more time may be allotted if specifically described in their ILP. If you look at it, the two sentences are, you just need to put an unless there, except that, and I think we can correct that very easily. But the question, the more substantive question is, a 30-day limit seems to work against the rapid rehousing provision and other provisions of the ordinance. So you're going to boot them out in 30 days. And I'm not sure that that is something that you really want to do, but again,
Would you suggest alternative language?
well, I know it sounds like weasel words, but unless, I would put something in like unless unless there's a demonstrated need for additional time. If they're in a detox program, for example, I don't know how long a detox program takes, but it might take more than 30 days. Some of them might, I don't know. So if you just soften it up, if that's the word, to give an out for special types of programs and things like that, I think you're going to be safer when a court would look at this on its face.
Okay.
And I already made the modification to the draft
Oh, did you? Okay.
just now, based
Oh,
on what you
okay.
said.
Okay, on 12A, management security plan ID is good. Minimum requirements continue to demonstrate the ordinance is designed to keep homeless shelters from being able to operate feasibly within the city. And maybe I shouldn't have made that so broad an editorial comment, but it was getting late, I guess. Again, this is, be careful that you don't have this be so difficult that nobody can realistically afford to do what it is that it's purporting to allow. And I think Mr. Sims kind of hit the nail on the head. Maybe when you started out, you were talking about a basic homeless shelter. Here, you're talking about a fancy homeless shelter that's going to be very costly. Again, you may want to have an ordinance that would allow either one, but they just need to tell you what they're doing and what they're going to be. If it's going to be a basic shelter, then have them submit a basic plan, but not have a one-size-fits-all, a very, very expensive type of program, if you can avoid it. And then,
Let me, can I back you up just a
Yeah.
little bit further? And that is shelter size occupancy. Have you any thoughts as to how much the city should have as an occupancy number? The concern is, of course, the mega shelter, the 220 beds, or the even 120 beds. I mean, do we?
well, I did cover this in here somewhere, maybe it's coming up, but I'm not terribly enamored with the idea of saying one per X number of residents for the city, because is that really the need? I would be more in favor of you looking to see what the demonstrated need is, or trying to get some kind of handle on the need. Maybe you only need a 30-bed shelter. I believe this was a 30, right? Limit to 30?
Right.
Yeah. Well, but then again, why are you limiting to 30 people? We do use, we do use ratios to populations in comprehensive planning, things like that. How many parks do you need, and what level of service do you need? So that might be arguable that would withstand scrutiny. On the other hand, why is it one per X number of residents? Is there any basis for that anywhere? And if you do some kind of a study, you might wind up finding out that it's going to be less than you thought. Maybe so. A little bit of data and analysis, and I think the county has some comments and figures, but probably not. It probably doesn't cover Bonita Springs separately. It might, I don't know, but maybe the county can help and help you figure out how to get those numbers.
A comment here.
Yeah.
I've seen your moment, sorry about that. Audrey made the analogy of a restaurant. Think of this in terms of a restaurant. If a restaurant comes to you and they want a permit, but they want to put a restaurant in to feed so many people. You don't have any problem with that. They need so much staff. You don't tell them how much to staff it, know what kind of staff there is. And when it comes to this kind of operation, somebody comes to you with a request that they want to build a shelter. They got to tell you what size of the shelter is. So we should specify an upper limit, perhaps, but you don't have to tell them what to staff. You don't have to tell them business. You don't have to have a registered nurse on that administers drugs, because we haven't talked about drugs. I don't know how to go further with this.
I understand.
Well, size and use of the facility, you usually find those things in the land development code sections, which you're going to be talking about also. But this is this says operations, so you're getting into operations. So, yeah, I don't disagree with your point. Again, I would tend to be somewhat of a minimalist on that and just have them tell you what it is you need to, that they need to provide and why, make the case, rather than have so many regulations of the shelter.
LPA kind of struggled with this issue before also, LPA and City Council, on big boxes or formula buildings, because it's kind of analogous that with a big box, you don't really want too many super centers. They're aesthetically different than other types of uses. And through the design standards, this LPA made modifications so that you break a building down so it does not look that way, so it integrates into the community. And I think the same issue is here, is integration into the community. What is appropriate to make an integration there? And whether that goes into an operational or whether it goes into a land use is a whole secondary issue there.
If I could, we've kind of broken away from the format we tried to do. We can hold the questions for now and let
Okay.
Bob finish his presentation.
I'm on page 21. Most of the time, where I say comment okay, then I don't think we need to really go through that unless you want to. On page 21, a little something about the floor plan of the facility. Just in case it's covered under Homeland Security, as our water plants and hospitals and things like that. It's kind of in the nature of a hospital. We'll want to make sure that we're not violating Homeland Security and domestic security issues. I did a paper on that for Florida, which one was it? City and County Local Government, and I'll share that with Audrey. I'm sure she has a copy of it in her files somewhere and reads it all the time. But there are some Homeland Security issues and airports, et cetera. And so it may be that those files would not be kept, or if you're requiring them to come to you, then you're going to have to make sure that they don't get out to the general public. And there's some laws on confidentiality pertaining to that. Other things, I had a couple things that were redundant, but I think we've talked about most of these. I'm going to page 22. On the comment under B, all applicable city departments, applicable service providers will review the permit to identify any potential increase in demand on services. That's okay. Any increase in demand on city department or other applicable service providers will require shelter operators to enter into an agreement to mitigate and offset any resulting increased demand. And somebody might have thought about that would be a good idea because you do that for environmental matters and so on. But we have to be careful because police and to some extent fire, general services, you cannot do a special assessment for general services. I cited in the footnote Collier County versus state, but I didn't get a chance to do the citation. There have been a couple of Collier County versus states cases, and that's one of the cases where Collier County thought that they could have what amounted to
The interim services
it
fee.
was called the interim services fee, so they made it look like a fee, but the Supreme Court said, no, it looks like a tax, walks like a tax, acts like a tax, it's a tax, and you don't have the authority to do that. So, so that could not, you might want to be able to identify costs, but you cannot charge them back the cost for general services any more than they could charge you for a police officer coming out to your house if you need it. So that's a comment there. Expansion of existing facilities. They have to start all over again. My comment is it's harsh but not facially invalid in my opinion. And on page 23, random inspection by any state or local agency at any time and carried out by inspectors authorized by law to see whether they are following housing, sanitary, food service codes. Supreme Court has already said you can't do that in a case called, I think I cited it, Municipal Court of San Francisco. They said that if code enforcement, you send code enforcement out, they cannot just go onto premises without having some type of cause, and we have a definition of cause in the state statute, which is all the states adopted those types of statutes after that case came out that said those are inspections. There are provisions for routine or area inspections, and a code enforcement officer can get out there and do inspections. I don't think it's necessary, and it's the way it's worded, you're just asking for trouble. There's a compliance plan required. That's probably okay. The only concern I have, or comment I have on some of that is, I'll bet you do have in your code of ordinances and or in your land development code a set of penalties, because all cities do. Well, I know you do, because yours came from the county, and so there are existing penalty and remedial sections in your code already. One of the problems you get is somebody starts to write and they say, oh, I have to put in everything. Well, you don't usually have to put in everything unless it's unique. Now, the one thing that might be unique is and I kind of doubt if it's unique, I haven't looked at that, but the provision that says they have to come to, there's a kind of like a due process provision where they have to come to council and come forward as to show why their permit should not be yanked. That may already be in your code, but if it isn't in your code, it's probably a good provision. You can't just pull somebody, you can't summarily or immediately pull somebody's permit and bring the police or the sheriff in to shut them down without having a darn good cause, emergency cause to do that, or B, you followed the appropriate procedures. That's called a procedural due process, and that's required. So you may not even need that section, and if so, then keep it in, but don't have anything that says that just automatically a permit is suspended. There has to be some kind of cause, suspended or removed. Going to page There are some things where I think there's some redundancies or surplusage to having to do with workers' compensation, which preempts local regulations. Annual reporting, I don't think I had a comment on that. Just be careful, the HIPAA law, I never can remember what it's called, Health Insurance Portability and
Protection.
something law. HIPAA, when you go to the doctor's office, you have to sign your HIPAA forms. Those are designed to provide privacy and protection against your medical information going out to the general public without your permission or without your knowledge, or even going to insurance companies. There are lots of regulations under the HIPAA laws, and if you're going to be doing all these things that you're talking about requiring a homeless shelter to do, having to do with medical and things like that, then a lot of those records are going to not be, or they're going to be confidential, and so you cannot require them to give out or even give to the city information that's otherwise confidential under HIPAA, under Americans with Disabilities Act, Family and Medical Leave Act, all of those kinds of federal laws. One thing that really bothered us a little bit, quite a bit, was H. G might be a little bit too intrusive also. Salaries, bonuses, and fringe benefits of employees. These are not public employees. So, in disclosure of relatives, work the same shelter facility. What the purpose of that would be, I don't know, but these are not necessarily going to be probably not going to be governmental employees. Most likely they're going to be private not-for-profit. There are rules concerning private not-for-profits in the nonprofit corporation law that says what has to be disclosed and what doesn't have to be disclosed. My recommendation is you stay out of it. But of more concern is listing of donations received by the shelter over $100. I will bet $100 that would not last 10 minutes in a federal court. It's nobody's business unless you're giving something to a governmental entity, and it's under public record. It's more or less nobody's business who donates what to a private not-for-profit. So I don't think you're going to be able to get into that. Somebody could prove me wrong, but and I've been surprised before in my career, but that one would surprise me if that stands. Accessible records, permit fee, that's up to you, but make sure that your permit fees are, and your annual fees are reasonable. And I already talked about revocation, and getting down to the end here, in violation and penalties, again, I think you probably already have the violation penalties and remedies somewhere in your code. If not, then the remedy you have up here that includes going to, not just summarily closing them down is probably going to be okay. Any questions?
There are probably plenty of questions. At times it gets confusing. Mr. Chairman, if I may comment.
Yep.
All in all, I think you addressed each one of these head-on, and the comments were I couldn't tell if they were statutory, case law, or your own opinion, but I thought they addressed all these issues. And these issues were the ones brought up by the public primarily. And from the looks of most of this, we won't be able to do most of these. We'll be able to do a lot of them, but there's some of the restrictions, medical and so forth, things that infringe on rights of others, we won't be able to do. And I don't know why a lot of that was put in, other than say that we want to be careful about the homeless shelter that we do put here, that we have requirements for them. And in one sense, we talk about a simple shelter, and then we talk about one that has all the bells and whistles. And how someone coming in wanting to open a shelter, how do they address what it is they want to do. And what you're saying is, let them say what they want to do, and then you react. But you do have to have something written to react.
Sure.
So there have to be...
Some standards.
Right, there have to be some standards that are set up, and which one of these that will pass, I don't know, but the ones that are case law or statutory law must be as is. And I think, Audrey, during our discussions, you've addressed, I think, all of these.
I
And I-
tried to.
And I think that having second counsel take a look at this and give us a fresh opinion was a great idea. And I think, who knows, we may get a third attorney here, and he'll give us a totally different impression.
Oh, we will if we're challenged.
So, from the public standpoint, what they might say is, well, do we pick the best 2 out of 3 comments that we like, or where does this end? And I don't know how we get to that point where it's not so restrictive, you can't do something feasibly or by law or something else. And that's where I get confused.
Right, and let me tell you where I envision, if LPA agrees with me, this is where I plan to go with this ordinance at this point. If you look at the ordinance draft that you have dated November 1, that's in your packet, you already have a section where the attorney removed the following due to legal issues. So these were some of the suggestions that never made it into the draft ordinance. And as you recall, we talked about it previously, I tried to be very conservative in taking things out of the ordinance. So unless I could really identify and pinpoint something that I thought was, quite frankly, atrocious, it's great to have a second set of eyes, because when you get entrenched and you're hearing the comments from everybody, and you're trying to draft things to recognize their concerns, I left things in the ordinance that I probably should have taken out. What I will do is, when I take it out, I will put it in the back row area so that, yes, we talked about it, it's in here, we took it out because of legal issues, per the memorandum, or, per our discussion, and then I will have a final draft that is a little more simplified. Remember, the final draft can always be changed, not just by council at the hearing, but it can be changed by council next year, 2 years from now, if we discover that there is an operational problem, if there is a shelter. So, there are things that I can do. So I can tell you some of the changes I'm going to make, but it basically is the same things that Mr. Pritt identified in his memorandum with Ms. Grady.
Okay.
I would
Is that
just
okay?
I would just echo what Sam said. I think it was very helpful to have this presentation. I hope it was helpful to the public also.
I've got a question or two. We've kind of skirted around one of the big things that we've talked about, public input, and that is, are we talking about, at this point, are we going to be able to come up with something before Audrey goes to council to ask for advertisement, to where we nail this thing down to some kind of a ratio or something that comes up with a shelter that is at least not a whole heck of a lot larger than 30 plus children under 6, one, for based on something? Or are we saying, no. So that, all that really means is we're going to have more than one. One may be one of these plain Jane temporary housing for the night shelter, and there may be another 30 or whatever size, which is grandiose. So I'm just asking that question. And then the other question I would ask, because I think, Mr. Bob, that you pointed out that there would be a benefit to having a maybe a more thorough or a relook at how many homeless we need to service. And I would concur with that. I think if we're in doubt that we don't know, then we need to find out so we can help justify whatever it is we come up with.
And my notes reflect on that issue that I was going to pretty much go with what number A is, as opposed to some of the other alternatives, but also see if, coordinate with Ann Arnell at Lee County, along with Janet Bartos from the Lee County Homeless Coalition, and you've met her before, she's come here, to find out if they have a number. And it might be that number gets adjusted during the process. But again, the concern of the mega shelter, I think, is a very valid concern. So, I mean, as far as size. The bunk bed issue was interesting because I never really thought about the doubling up. You know, if you have an occupancy issue, I mean, does it really matter whether, and we talked about, I just took my son to college. Does it really matter whether the beds, it's up to the people, if they put the beds and they double up so they have more space, as opposed to having the bed single? Now, I'll tell you, most of 18-year-old boys do not keep the bunk beds. They like to have, they don't care about the space as much as they care about having their own space, as opposed to being on the top or bottom. But, you know, why is that a government interest? I mean, that's a question I have for you, you know. I don't necessarily know if it is or not. So if you have an occupancy number, does it matter if it's a bunk bed or not? I mean, to the LPA.
I have a question.
Okay. One more question, then we're going to take a short break. Go ahead.
In our definitions that we started off with, I have a couple of questions. First thing, housing first and rapid rehousing does not appear anyplace in my definitions. So to have it appear here is a kind of a surprise to me because I don't really know what it means.
And I have looked it up before. It's generally, it's a theory in, I keep saying affordable housing, but in homeless, there are groups that what they do is it's very social worker intensive driven. They take a person that they might find from the streets who is homeless, and they move them into their own apartment. They dilute them from the source. So you don't have the homeless camps. You now have a person living in an apartment that's in a normal apartment building along with everyone else.
Well, how does that
It's a
apply
main-
here? I don't understand.
I mean, it's a mainstreaming program that's out there in homeless. It's a term that's used in the homeless.
That comment
community.
came from Margaret Wurtzley, a meeting that I had with him, and I think it was Councilman Simmons. And what she said was, and that may not be, we may have a wrong definition, but said the type of shelters that create the biggest problem are the ones where they take in practicing drug addicts, people that are really, should be in a different place than just temporary housing. That's what this housing first reference was to. That may be an incorrect definition, and it may be that Bob will tell us that we can't do that too, but at least that's what it was intended for.
Right. A lot of times, the housing first does not have a dry requirement, so the person will continue drinking inside there. Or you may have a situation, let's say a person who is schizophrenic, and this is through my talks with St. Matthew's House. If you have a person who is schizophrenic and they're hearing voices, and the medicine, I guess, there's different times when you're on the medicine. Sometimes it's working full strength, sometimes it's wearing off. You don't necessarily want to house them in an area where there's lots of other voices, other people, because they can't necessarily ascertain. So, I mean, in fairness, so what they try to do with somebody in that situation is provide them in their own shelter facility. So if they're hearing voices, they know that those voices are not just their roommates. That's not because they don't have roommates. So that type of shelter would be prohibited. And I don't know if that makes sense, because again, now you have a person that, but for their economic situation, let's say somebody is schizophrenic, but they live in Bonita Bay because they're affluent, are you now justifying based on just their economic situation?
I have the second half of my question. When we started out, we had a definition for the group 4 that we were to follow. And so in the ordinance, we have independent living plan, and as it's spelled out here, it must include training and finance and job training and so forth. But yet in our definition of what we're supposed to be doing here, there is no rehab or no training involved here. It's a temporary living facility with personal and social problems, and then that's it. There's no nothing else included in what we're supposed to be looking at. And yet, we have this ILP plan in here which specifies things that I think are outside of the definition that we started off working with.
And there are some concerns, and do you want to answer, or do you want me to?
No, go ahead.
And the concern are the cases that we looked at on the other coast, I keep saying the breakers, but the West Palm and Delray, dealing with the rehabilitation facilities. And if you're starting to get into housing of people and focusing on mental health, focusing on alcohol abuse, drug abuse, you're really now getting into a situation where you can violate the Americans with Disabilities Act. So in trying to make sure that we're not discriminating based on a protected class, i.e. Drug abuse or drug recovery or mental health issues, it is omitted from this ordinance because that would be one where the ordinance would be stricken. And courts have been striking ordinances like this.
Do we need to
regulate that.
modify our definition of our Group 4 definition then, if we're going to start including things that, in my mind, fall outside of our definition?
Well, are you now talking about independent living facilities? Are you talking about homeless shelters?
Now, when we started out on this months ago, we got definitions of what we were working with, and my understanding is we're dealing with Group 4, which specifically is a temporary living facility. There's no mention of any rehab or training or anything else in our original definition. And yet, over time, and I'm not saying there's not a need for this, I'm saying that our original marching orders here did not include this.
Right.
And so do we need to look at our original plan, modify it?
Yeah, I think we need to look at it, but if you're going into, and I guess I'm having some confusion if you're asking for the operational shelter or now we're in the land use section.
In the operational shelter, it has an independent living plan that'll be implemented within so many days, and it will include certain things. Training, finance and job training, for example. And so we're mandating that they do that, and yet in our definition, it's not included.
Let me take a look at it with Mr. Pritt.
Yeah, I think it'd be a good idea to make sure that the definitions in both places are
Consistent.
synchronized, and I presume that will be done.
That's looking at the definitions to make sure they match is probably a good idea. But the intent was, as things developed, you're exactly right. Input from the citizens and other people that we discussed realized that not all shelters do the same thing. And we weren't going to require all shelter operators or whoever may request permission to operate a shelter in Bonita Springs to do the same thing. In recognition of that, some facilities may provide services that others would not. And that's why you see some guidance or regulation in a certain portion of the ordinance, but not in other portions.
But you're going to issue a permit for a Group 4 home.
Yes,
You're not
sir.
going to just issue a permit for a homeless shelter. It's going to be one of the various classifications that we've identified.
Yes, sir. And under that definition, it also includes in ancillary social services as may be provided. But those ancillary services would need to be included in their permit request.
Right.
So we would know what they intended to do. And if they do certain things, there are certain regulations in place to guide
Well,
them.
in my mind, I hear what you're saying, John, but in my mind, I'm looking at it and say, okay, once we got a permit for a Class 4, we could do things that are included in Group 5, for example.
All uses that an operator intends to have on their facility needs to be included within their application. So if they intend to perform uses A, B, and C, they need to include those within their permit application and state how they're going to function with those uses. So they may ask for several things, but once that's approved, assuming it is, those are the uses they're limited to. They cannot simply go out and add uses as they see fit without additional approvals. So there may be other uses that they could request, but unless those uses are approved, they cannot operate with those.
We'll also look at the need then. You could be approved for a use and then find out that the need for that particular function is not as great as was anticipated, because as it appears to me from the testimony we've had here, there's a great deal of range in the need requirements in Benita Springs. I mean, it ranges all over the place, depending on who's testifying. So when a person would get a permit for a certain function there, his need may not be as great when it actually gets into practice.
Yes, sir. And that's no different than any other type of use. And if the need is not there and they decide not to use it, there is nothing that needs to be done other than they cease providing that service. If one need is not as great as they thought, but another need is greater than they had anticipated, then they would need to come back in to request that additional use to provide that service.
Okay, so that's exactly where we wanted to be. Because now when they come back in to make a change in that, are we back to the city council thing?
Yes, sir.
Or are we back to you?
City council, because you're talking about a use. That would need to be approved by the council, and in my mind would be looked at as an expansion of the facility, because it would be the expansion of a use.
John, if I could ask you one question, just one. Would this be similar to the laws set up or the statutes set up to differentiate between, in healthcare, a walk-in clinic from a hospital, from ambulatory care and those kinds of things? Isn't it very similar to that?
I think you can make a comparison.
Yeah.
I don't know if they're identical, but you can compare those.
Audrey and I were talking about that point before the meeting started, and that very issue. When you're doing this, you look at uses that are similar, not identical necessarily, but that are similar, and that's exactly right.
Does that answer the question, Mr. Sims?
Yes, sir, but I have another question. While we're
Here for.
One of the things that we're asking for is annual reporting, and that annual reporting has to have certain information in it. Well, under the Sunshine Law, that once it's given to the city, that's a public record, and so that information would be available to anyone that asks for it.
Yes, sir.
And so my question comes up is, how is that protected?
Protected it from who?
Well, I mean, how would the information on there
And let me,
help me?
It would have to be in the format that it was submitted. It wouldn't be in what was done with that information once it was turned over to the city, meaning that the format the information was prepared would need to be in a way that it didn't violate any regulation and would not injure or
Wouldn't be
harm anyone if it was
identifiable
distributed.
names or social security numbers or anything like that.
That's
unless you
exactly right.
donated money.
Right, and
Oh, yeah.
that's, I've spent a whole lot of time recently dealing with that very issue. Just because it is a public record does not mean that that anybody can see it at any time. For example, if somebody sends in a social security number, it's up to the city to redact or delete that and before it goes out to anybody else. Now, the smart thing to do is don't require them to submit things in a form that would not be, that would create a confidentiality issue in the first place. And cities and counties in Florida are learning how to do that better, to get the public records available out there, but not to be requiring things that would create a violation of the state law, the federal law, medical records acts, things like that.
Social
But
Security.
somebody here in the city staff has to make that form up, has to design that form. I mean, there's not something that you can go on
Yes, sir.
the internet and pick up a form
No,
for
but,
this.
well, unless you're trying to require it. So the advice for you is, and counsel is, don't be requiring things that you know are going to be,
We're requiring an annual report.
right.
And so if the annual report doesn't have real meaningful information on it, there's no sense in collecting it.
No, but on your annual report, if you're saying that you want the medical information for for this person or that person, and so on, first place, you're not going to be able to get that yourself, probably, so. And if you do, then it can't be,
Right,
Put out to the general public.
and I'll give an example. The city does not, city runs on government light. We do not deal with, we don't have a social services office. Lee County administers most of our social services, including like assistance on our community development block grants. If we chose under our CDBG to do a lot of building rehabilitation, they need to look at a lot of records dealing with personal folks' economics, their tax forms and such. Just because that agency gets those tax forms doesn't mean everybody else can see it. Our finance people look at records from Department of Revenue, so to make sure we're collecting the correct amount of taxes for certain things, or make sure they're collecting the right amount of taxes. But, I mean, they're sworn to a secrecy, and they cannot release certain information that, could become proprietary and useful to someone else. If the items in 16 on page 13 are meaningful as a reporting, and you think it would help or assist in the operation of the shelter and the operation of the city, then by all due means, collect the information. If you think that it has no value, do not make an annual reporting requirement. I do have my notes reflecting that G and H to take those out, because there probably is no governmental purpose in a reporting requirement. Some of it might just be for spite, and some of it, again, privacy, there are some privacy rights for people out there. And certainly donors, you don't want somebody harassed because they've made a donation to an organization, or how much their donation is, especially if they want to remain anonymous. 501c3 laws there. So, I mean, take a look at that. If there's some other ones, that's by number of residents, as opposed to, now if it's clearly identifiable that only one resident, has this, or if it's identifiable because 97% of the residents, I might have a HIPAA issue. But that's why we did by number of residents as opposed to listing out the residents on that form.
Okay, take a short break. All right, I know we have a lot of comment, and if we haven't thoroughly confused you by now, we'll do that right after the break. So just 10 minutes, folks, so we can, otherwise we're going to have to order in lunch. Reconvene at 10:40.